You followed every instruction, paid every fee. You waited months, maybe years, with your life on hold. But now, all of that could be wiped away in seconds because of a single policy update quietly rolled out by USCIS that has blindsided thousands. No headlines, no press conference, just one change. That could cancel your American dream. Are you next? Introduction. Setting the tone. Welcome to a deep dive into what is perhaps one of the most quietly devastating changes to U.S. immigration policy in recent memory. This isn't political commentary. This isn't speculation. This is official, implemented policy, and it's already impacting thousands of applications, from green cards to work permits, student visas to asylum requests. We're breaking down exactly what the new USCIS guidance says, why it's controversial, who it impacts most, and, most importantly, what you need to do to protect yourself or your loved ones. Because while the government might not be sending out alarms, we are. Section 1. What changed and why it matters. Let's start with the core issue. In late April, USCIS introduced a policy update giving adjudicators, USCIS officers, expanded discretion to deny applications outright if initial documentation is deemed insufficient. What's missing? No RFE, request for evidence. No NOID, notice of intent to deny. No second chances. For applicants who have spent months preparing submissions, one missed form, one incomplete supporting document, or even a non-certified translation can now mean total denial with no warning. Section 2. The policy text. Decoded Let's. Decode the language from USCIS's official policy memorandum. It states, officers may deny a benefit request for failure to establish eligibility based on a lack of initial evidence without issuing an RFE or NOID. That sounds bureaucratic, but here's what it really means. You must prove full eligibility up front, no supplemental documents later. If your evidence is not persuasive enough in the first review, the case can be denied immediately. And because this decision is discretionary, it's harder to appeal. This seemingly minor internal change has massive external impact. Section 3. Why this is a break from tradition. Historically, USCIS used a request for evidence process generously. Applicants were notified if their documents were incomplete, inconsistent, or needed clarification. It created a dialogue. That's gone now. This isn't about encouraging better applications. It's about cutting them off faster. It's not just efficiency, it's elimination. Section 4. Real case scenarios. True stories. Let's bring this closer to home. Case 1, Maria, family-based petition. Maria, a U.S. citizen, petitions for her husband from El Salvador. She forgets to include one translated page of a birth certificate. The officer doesn't ask for the missing page. Result? Application denied. She now must restart the entire process. Case 2, Ahmed, H-1B visa. Ahmed's employer used the wrong wage level in the labor condition application. It's a common mistake, but one easily corrected. Under the old policy, RFE, now instant denial. He loses his work status. Case 3, Fatima, asylum seeker. Fatima provides personal testimony but limited physical evidence due to fleeing persecution. The officer deems it inadequate. No RFE issued. Her case rejected. These aren't technicalities. These are people's lives, upended by silence. Section 5, the data, what we're seeing so far. Immigration law firms and watchdog organizations have begun compiling preliminary data since the new policy rolled out. RFE issuance down by over 35% across certain categories. Denial rates up by 18 to 22% on average, especially in family-based and employment-based visas. Higher rates of denial among pro-SE applicants, those filing without legal help. Spike in referrals to immigration court following denial. This policy isn't just theoretical, it's reshaping immigration success rates in real time. Section 6, what USCIS says versus what critics believe USCIS official justification. Streamline processing, reduce backlogs, improve efficiency. But critics argue why this is an invisible wall, policy used as a weapon. It burdens the most vulnerable, people with limited English, limited money, limited support. It increases fear and decreases trust in the legal process. It's policy wrapped in paperwork, but underneath it's exclusion through technicality. Section 7, the groups most at risk. This policy does not impact everyone equally. Here's who is especially vulnerable. 1. First-time applicants unfamiliar with documentation rules. 2. Low-income families unable to afford legal representation. 3. Undocumented individuals trying to adjust status. 4. International students under tight timelines. 5. Immigrants in removal proceedings submitting last chance waivers. 6. Employers sponsoring workers with complex compliance steps. Even minor. Correctable issues can now destroy years of work and waiting. Section 8. What officer discretion really means. Officer discretion sounds neutral, even fair, but it means one thing: subjectivity. 2 officers could review the same application and reach completely different conclusions. No appeal, no explanation, just a single judgment call sealed with a stamp of denial. Section 9. The psychological toll for many applicants. The waiting period is already stressful, but now anxiety is amplified. Did I forget something? What if the officer misreads my paperwork? What if I never get to explain my side? This stress is multiplied for families awaiting reunification, students on deadlines, and workers whose legal status hangs in the balance. This isn't just legal pressure, it's mental pressure, and it's growing. Section 10. Policy context. This isn't random why now. Analysts point to several strategic motives: a surge in applications post-pandemic, political pressure to tighten immigration without congressional battles, budget shortfalls within USCIS prompting faster rejections to lower caseloads, a broader effort to appear tough on fraud without increasing transparency. This change avoids public scrutiny because it's administrative, not legislative. Section 11. What this means for future immigration trends. The effects of this policy will ripple outward for years. More cautious applicants, fewer willing to risk applying, greater reliance on expensive legal services, longer family separations due to resubmission delays, fear-driven dropouts from employment-based visa pipelines, increased litigation against USCIS in federal courts. It may also contribute to talent loss as international professionals seek friendlier immigration environments. Section 12. How to build a bulletproof application. Now more than ever, your application must be airtight. Here's your checklist. Include all required primary evidence. Use only certified translations. Double-check all signatures. Forms and attachments. Add secondary evidence to support your case. Organize documents clearly. Add table of contents. Submit well before deadlines. Include a cover letter summarizing eligibility. Don't rely on common sense. Rely on precision. Section 13. What immigration lawyers are saying immigration attorneys nationwide are advising. If you don't know how to prepare a complex petition, don't do it alone. This isn't a time to gamble. Mistakes are no longer forgivable. The policy has turned minor errors into major consequences. Many lawyers are now offering pre-submission audits just to spot errors that could end the entire process. Section 14. A global signal to the world. This policy sends a chilling message. Even if you're qualified, even if you follow the rules, one wrong move can end it all. For nations that once viewed the US as a beacon of opportunity, this change feels more like a warning. Other countries, Canada, the UK, Australia, are watching and competing. As America adds silent restrictions, others are streamlining paths for skilled immigrants. Section 15. Final thoughts. Your move matters. This policy is already here, but your awareness is your greatest tool. Your preparation can protect your opportunity, and your voice, your story, can push for reform. Section 16. The growing backlash, lawsuits, protests, and political pressure. As the policy's consequences spread, the reaction has begun to build. Immigration law organizations, human rights groups, and even former USCIS officers are pushing back. Several lawsuits have been filed against the agency, claiming violation of due process, applicants aren't being given a fair opportunity to respond. Discrimination, denials disproportionately affect applicants from Latin America, Africa, and the Middle East. Administrative overreach, USCIS has changed the rules without proper oversight or public comment. At the same time, grassroots protests have emerged outside USCIS offices in cities like Los Angeles, Chicago, and New York, with signs reading "Process, not punishment" and "Fairness first." Even congressional representatives have started asking questions, with bipartisan calls for USCIS to release denial data and justify its policy shift. This is no longer a bureaucratic change. It's becoming a national conversation. 17. How AI and automation are changing USCIS decision-making. Another dimension often overlooked is the quiet rise of automation and AI in immigration adjudication. Internal reports suggest that USCIS is now using AI-based systems to pre-screen applications and flag likely denials. These tools scan for that missing documentation, discrepancies in addresses or dates, language errors, prior immigration history, or status issues. While designed to improve efficiency, experts warn this introduces new risks. Algorithms are not